Good afternoon. This is the House Judiciary Committee. It is, I don't know, April 2nd. April 2nd. Sure, April 2nd. About 2:45. We have three bills that are concurrences that are in the same posture of Senate bills that we passed. First is a task force that is Delegate Cardin's bill on fiduciary adjudication in Maryland. Yes, very exciting. I would just like to emphasize for the committee that voting to concur in the Senate's amendments here does not mean you have to serve on this task force. All right.
Oh, that's good. And what number?
This wouldn't be on the voting list because it's a concurrence, but we're working off of, in a moment, we're working off of voting list 17. Same one from this morning, 17. But the concurrences for those keeping score at home will be on House Bill 315, 616, and 123, and I'll do them one by one. So the concurrences, again, so 315 passed, we would be concurring in the Senate's amendments, I believe. Could I have a motion to concur in the Senate's amendments on House Bill 315? Motion to concur in a second. Any discussion on the motion to concur? Seeing none, all in favor of concurring in the Senate amendments, please raise your hands. Anybody opposed to concurring? All right, it's a task force and we're so excited. All right, so we concur in the task force and look forward to Delegate Cardin serving on behalf of all of us. House Bill 616, this is Delegate Hutchinson's bill on funerary objects. You'll remember that earlier today we voted on the Senate bill, so we're concurring in the Senate amendments here on House Bill 616. There's a motion to concur. Is there a second?
Second.
Second, thank you. All right, so any questions about the motion to concur on House Bill 616? Seeing none, all in favor of concurring on House Bill 616, please raise your hands. Anybody opposed? A couple people left their hands up too long, but we had a majority to concur, and so we concur in the Senate amendments to 616. House Bill 123 is it's a bill on membership of the Maryland Correctional Training Commission. We would be, the motion, I believe, is to concur in the Senate amendments. Can I have a motion to concur? There's a motion to concur and a second. All right, so this would concur in their amendments, which I believe added a member of AFSCME. I think it added a member of AFSCME. One moment, please. House Bill 123.
Oh, yeah.
Yes, I think it adds one parole and probation employee of the state recommended by the exclusive representative for parole and probation. So it adds an AFSCME representative to the membership of the Correctional Training Commission. So we'd be concurring in that amendment. There's a motion and a second to concur. Is there any further discussion? Seeing none, all in favor of concurring, please raise your hands. Anybody opposed to concurring? And that motion is adopted. You can, there you go. All right, so those are the concurrences. We're now going to go to Senate Bill 444. Senate Bill 444 is from the chair of the Judicial Proceedings Committee. It is about gun buyback programs, and I believe there is an amendment, 403023.
Move the amendment.
Motion for an amendment and a second. The amendment, I believe, if memory serves, as I go looking for the part again, it would require that the law enforcement agency that receives a firearm from a gun buyback program shall make reasonable efforts, including conducting an investigation if the law enforcement agency deems it necessary to make sure that to see if the gun was involved in a crime or was reported lost or stolen. So it strengthens the language regarding making sure that they do an investigation. If it's determined that the gun was reported lost and stolen, then they have to take steps to return it to its rightful owner. I believe that addressed some of the concerns with the bill. Delegate Conaway.
So this only is in reference to law enforcement doing gun buybacks? Remember, we had that
yes.
question on the,
Yes, it's only law enforcement run gun buybacks, correct.
thank you very much.
Anyone with any other questions? We have a motion and second on the amendments. All in favor of the amendment, please raise your hands. Anybody opposed to the amendment? Don't see anybody. Amendment's adopted. We're on the bill as amended. Motion for a favorable and a second. So we're on the bill as amended. I believe it addresses one of the concerns from opponents to the bill. Oh, yeah, that's fine. I'm just going to call the question in a second. Any further? Delegate Grammer.
Yeah, thank you, Mr. Chair. So if I remember, there was a, one of the complaints of the opposition was that as drafted, there was a concern that folks would violate 4203. That's illegal possession. Has that been addressed? I didn't see, even with that amendment, it's been addressed currently.
So if they participated in a police-run gun buyback program and somehow they were themselves restricted from possessing a firearm?
I believe it was the sensitive places. It would be potentially illegally possessing it to carry it to the buyback.
I think this would make it harder to have a gun buyback program at one of those sensitive places, so I presume they wouldn't be at one of those sensitive places.
Well, there are a lot of sensitive places. I mean, there are a lot of...
Police station not being one of them.
But it's not limited to a police station, right?
Federal firearms licensees?
It's also FFLs, which are not, they're not those places either. Yeah. I think the idea behind the amendment was to go some way to make sure that they weren't guns used in crimes and make sure that if they were lost and stolen, they were returned to their owners. I don't think we can foresee every single permutation of what could happen.
And I think that was part of the amendments because they struck a person or entity and specified those two groups.
Yes, so they specified the two groups, including an FFL
And law enforcement agency.
and law enforcement agency in order to avoid that situation where they would have it at a sensitive location, because neither one of those two would generally count as that.
Yeah, as introduced, it said a person or entity. It was much broader. Yeah.
All right. Delegate Taylor?
Thank you, Mr. Chair. Just for clarification, because I know one of the most successful buyback programs in, well, not necessarily my district, but in our area, was at a church, large church. And I know they do that regularly. So are you saying that this would not prohibit them from doing this?
What this bill does is it talks about the rules related to the destruction of firearms that are purchased as part of a gun buyback program. The amendments that we're adding would go so far as to make sure that the guns that are purchased back are not ones that were used in a crime or were lost or stolen. I think it's beyond the scope of, I mean, if this were a bill that went to the larger issues of where you could have gun buyback programs, I think that's maybe a different bill than this is. So this bill doesn't directly speak to that. Delegate Conaway.
And thank you, Mr. Chair, but just to clarify what the good delegate was speaking about, for informational purposes, it could be somewhat illegal for a non-firearms entity to be participating in a gun buyback program.
It could, but they would need to work with their police departments anyway to make sure. I mean, the fundamental part of this is they have to coordinate, the ones that the Archdiocese did in Baltimore.
Yes.
Over, yeah, you know, they all do them in conjunction with the police department and make sure that they.
So, thank you very much, Mr. Chair.
Yeah,
So it's
okay.
just making sure.
It's just making sure.
So they should be fine.
Okay. Seeing no further questions, the Vice Chair?
Yes.
Yes. Valentine? No. No. Crutchfield?
Yes.
Yes. Cardin? Yes. Yes. Tomlinson? No. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. No. Simmons? Yes. Boucher? No. Phillips? Yes. Stinnett? Yes. Congolo? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right, favorable motion is adopted on 444. Okey dokey. Now, we are at 6, did we do 621? We did. All right, we're not going to do 828 just yet.
I made those changes in background. Do you want that to go out to them right now? But it does not include.
Yes. Go ahead and send, there were some changes proposed to 828. We're going to send them out now. I think we'll give people the opportunity to look at them. Now, there are two bills that are moving in concert, and we'll start with Senator Hester's 655. This is the cross-file of Delegate Cardin's bill that sets up an artificial intelligence evidence clinic pilot program to be run by our friends at the Judiciary. The Senate bill has an amendment for 373728. The amendment makes, I think I would argue, a technical change, if I'm not mistaken. It makes a technical change in the bill.
And clear, so here, I can.
Yeah, why don't you, yeah,
So
there we go.
the Maryland Judiciary had an issue. They wanted to make sure that the agreement between hold on, let me go back, sorry, I pulled up the wrong one. 655. One moment. Okay, so these amendments provide that the agreement between the office and the courts may include a certain hold harmless clause, and it doesn't have to. And the Judiciary wanted that clarification. And then some of the language that came across from the Senate still had entity and management of the program, but now the program is going to be handled by the administrative office of the courts. And so we had to clean all of that up. So that's what you're going to see. It's, instead of entity, it says grantee.
All right. Are there questions? Did we move the amendment? Let's move the amendment. And then I see there's a motion and a second on the amendment. Fine. Discussion on the amendment. Delegate Schmidt.
So we did not move the House Bill 966? We're going to move that with it?
Look at the voting list. It's coming track.
I didn't see, okay. Oh, it's ahead of it. I got it. All right, perfect. Thank you.
All right. All right, motion was to accept the amendment. All in favor of the amendment, raise your hands. Anybody opposed to the amendment? Seeing none, the amendment's adopted. We're on the bill as amended. Motion for a favorable?
Second.
And a second, all right. On the bill as amended for Senate Bill 655, Delegate Cardin.
Just to remind everybody, when we had the hearing on this bill, there was a question about the fiscal impact, and the amendments that were originally drafted dealt with that to make sure that there's no fiscal appropriation or requirement now, and so the bill is fiscally neutral.
All right. Any, yes, thank you. That was a question someone was supposed to ask, wasn't it? We had it all arranged so that that question would be asked, and it, I don't know how you do it, Delegate Cardin. All right, thank you. All right, so we've dealt with the fiscal note issue, and here we are. Any further questions on the bill as amended? Seeing none, the Vice Chair?
Yes.
Yes. Valentine? Yes. Yes. Crutchfield?
Yes.
Yes. Cardin? Yes. Yes. Tomlinson? Yes. Embry? Yes. Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Yes. Simmons? Yes. Yes. Boucher? Yes. Yes. Phillips? Yes. Stinnett? Yes. Yes. Congolo? Yes. Yes. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? Yes. Moon? Yes. Yes. Conaway? Yes. Yes. Kaufman? Yes. Yes. Williams?
Yes.
Yes. All right, so the House version of this bill, there is an amendment that would now conform the House bill to what we just passed in the Senate bill. And that is, I believe, 223829, number 1. Could I have a motion on the amendment? There's a motion and a second on the amendment. Any discussion on the amendment that would conform it to the bill we just passed? Surprisingly not. All in favor of the amendment, please raise your hands. Anybody opposed? All right, the amendment is adopted. I'll take a motion, looking at you, Grammer. I'm taking a motion, if somebody wants to remove the votes from Senate Bill 655 over to House Bill 966, so that they're in the exact same posture, including the person who voted no. Is there any objection to that? Seeing no objection, then we will do that, and Hunter's head is exploding. All right, that is fine. Hunter has a whole closet of new heads for when these things happen, all right? And so that's fine, and that will move us right along to House Bill 883. So, House Bill 883 was reviewed in subcommittee, and now it includes several of the bills that have come back year after year that we've sought to put into one vehicle or vessel, so to speak, to address them all at once. It takes the amendments, which are 903121, would take the following bills and put them all together. One, I believe it's Delegate Grammer's bill that would address the reckless driving and needing to, and making it a must appear in cases of reckless driving, but it provides a backdoor if both sides agree that the person doesn't need to appear. It also, it takes amendments to Delegate Wims's bill as it came out of the Senate, as the Senate version came out of the Senate, which we, I believe, have already passed. It includes that language from his bill that creates a new form of criminal negligence. And it also takes Delegate Schmidt's bill and includes that in this bill to the failure to remain in the case in the boating accident. So it merges all three of these into one gigantic container and sends them all to the Senate so that we can do this all at once. Delegate, so let me have a motion on the amendment.
Move the amendment.
So motion on the amendment and a second. Discussion on the amendment, Delegate Boucher.
This bill will satisfy what the A-Beat bikers have been trying to do on a separate piece of legislation?
Good Lord, yes.
Thank you. Well, I enjoyed seeing them.
I enjoy seeing them too. I've seen them in court, and I've seen them all kinds of places. Delegate Moon.
Mr. Chair, I hate to be poopy, but
Is that a technical term?
is the version that we are looking at right now the one that was emailed in a version called Amendment Packet 4.2.pdf? Okay, so if you turn to page 2 of the bill, where it has a section 3-212.2, I have a question about what this section is trying to do. The way I read it, a person may not drive or operate a motor vehicle in a criminally negligent manner, and then it proceeds to define criminally negligent manner as you didn't see a risk or what have you, and then it puts a criminal penalty on that for 6 months. What I didn't see there was that you had caused an injury or anything like that in order for this jail time to apply. So maybe I'm missing something just in what's there on that page, but if I read A and D of that section together, it appears to contemplate jail time for accidents where there was no physical injury. So I went and looked at the surrounding code sections, 3-211 E, 3-211D, and 3-212.1B, and these are all phrased almost identical except for one thing. They all require a life-threatening injury to have happened to someone. And this language does not include that life-threatening injury requirement. So I just want to flag, I'm not sure if that was the intent, to apply jail time to a non-injury scenario, but that's how I'm reading this, and it's different from how we've done all of the other bills with this kind of language.
So that my understanding is that is in fact the goal of Delegate Wims's bill was to create a second version of criminal negligence where they meet the standard for criminal negligence that person should be aware but fails to perceive the person's conduct creates a substantial and unjustifiable risk to the safety of persons and property, and the failure to perceive constitutes a gross deviation from the standard of care that would be exercised by a reasonable person. When there is an injury, it carries the 1 year. This would say that if those things happen and there is not an injury, that it would carry as a maximum of 6 months.
So someone could have been injured, and now
Yes.
all those non-injury accident cases are jail cases.
They could be,
And
if this were charged.
They all get a public defender.
They could be. This is one of the things that was in fact sent over from the Senate that goes to this issue. And if we'd like to think about it some more, that's fine. There are some bigger questions that come with a lot of these bills that come before the committee in this area of the law where to your point, there is not a dead body or a severely injured body there, but that goes to the facts of what happened in the police officer's case on 270 in that they were not, I don't believe that they were injured. Well, actually, no, he was injured because of another driver who did hit him. This is going to try and close that loophole with the egregious conduct that is criminally negligent versus reckless driving, which is a step below that. Delegate Moon, then Sample Hughes.
I mean, I'm looking at the other circumstances here. They involve alcohol or an injury for jail time to kick in. And this does not. And it appears to encompass the world of auto accident cases as being jailable cases. I've resisted us heading in this direction in previous years and voted against bills that did this. And at the moment, I don't know.
Chair, and I'm just going to use the words that you just described when you said a dead body or an injured body. In the case that I'm concerned about is that it is an injured, actually a dead body. The constituent was advocating, has been advocating for this bill, the part about the must appear part of it. So what we're doing now with these amendments, would that provide any jailable time for the person who has killed someone?
For the person who has what? I'm sorry.
The person who has killed someone. So this mother has contacted.
These amendments, no. The other two crimes that are being added here don't directly address that issue, but they would already, I would argue, they could be subject to vehicular manslaughter, depending if they died or not. They could be subject to criminal negligence if they died. That's consistent with what Delegate Boone said, and that carries a maximum of a year. What this bill seeks to do, its main part, is it seeks to close the gap between criminally negligent behavior, but it does not actually result in the actual death or injury of the person. So it doesn't go to the specific scenario that you're laying.
Okay, is that not what the must appear advocates have been advocating for?
So on that bill.
That we've now put together.
That is, they were charged with reckless driving.
Right.
But they were only charged with reckless driving. They weren't charged with anything else. So the state's attorney looks at the case and says, it doesn't rise to the level of vehicular manslaughter or criminal negligence. It's only reckless driving, which which is a payable ticket. The issue that they raise is because it's only a payable ticket, that person doesn't have to go to court
Right.
to see the family of the person who died or was severely injured. So what that does, it makes reckless driving a must appear that says that the defendant has to show up and they can't just pay the ticket and leave unless their counsel talks to the state and everybody agrees, presumably in contact with the victim, that they would not have to actually appear in that case. That doesn't go directly to whether it's jail time or not. There's no jail time on reckless
Okay, so that's like a separate
driving.
issue.
Yeah, that's a separate
But this
issue.
would at least get them, and I'm saying them, the must appear folk, someone to appear
Yes,
unless those other parties
yes,
agree
unless
to
everybody
not
agrees
appear.
that they don't need to.
Yes, okay,
Yes.
okay, so it touches it a little bit.
It
Thank you.
does.
Okay.
Delegate Embry, then I see you.
Thank you. Just building on what Delegate Moon was saying, when I read 3-2122.2 and what was sent around, I don't even see a requirement of an accident. It just seems to create a jail penalty just for, and then my other problem, which I've had from the beginning, is the definition of negligence is so similar to our existing definition. I don't know how you would parse the two. And so it just logically seems to me that if we're going to do this, we should be merging those two.
Some would argue that the distinction between the standards is relatively modest.
Yes.
And between vehicular manslaughter and criminal negligence. And this is one of the challenges that comes up as we continue to kind of create further divots within the bill and within the law. It does make it.
Because this will make every negligent driving case a must appear, accident or not.
I don't think that, no, I don't agree that every negligent driving case or even every reckless driving, because it still has to meet the higher standard that it was a gross deviation from the standard of care. Interestingly, 11 or 12 years ago, in this very same room, look at Embry, don't use that face. In this room, 11 or 12 years ago, was a long debate, excruciating debate even, on creating criminal negligence and trying to figure out what the difference was between that and a vehicular manslaughter standard. And at that time, we stuck the landing with this, and then Delegate Wims's language seeks to narrow it down kind of even more to another set of another circumstance. So I take your point, but that's the point of his bill. That's what we're here to consider. Okay. Delegate Cardin.
Thank you, Mr. Chair. Thank you. I appreciate this discussion. Actually, I really like Delegate Schmidt's bill and Delegate Grammer's bill.
Yep.
Parts of this legislation, which was brought up by Delegate Sample Hughes. I do have some concerns about this, which I was discussing actually, and I just want to give you the scenario that Delegate Embry was bringing up those concerns. That I had on the first day of that I had my new car, I was driving on 695, and I was in the left lane, a person in the middle lane came over, didn't see me, and almost ran me off the road. And I swerved out of the way, and amazingly, thank God I was in the left lane, because if I wasn't, I would have hit somebody on the other side. There was no accident. Did he meet this criteria? He was certainly negligent in how he drove. But was he criminally negligent? I would say possibly. I mean, it depends on how well the police officer who might have been behind me, because the only way this would actually have been dealt with is if the police officer was actually there and saw it. And the police officer could have said that, yes, he was deviating from the standard of care that would exercised by a reasonable person. There's no doubt in my mind, and if he was on his phone, so every time that somebody is alleged to have been on their phone and swerves near somebody, they could be, I mean, depending on how good the officer is at arguing the case, they could be liable for criminal negligence.
If they're showing a gross deviation from the standard of care.
Well, I mean, so you're not allowed to text, and you're not allowed to swerve into somebody's lane.
No.
And, almost hit somebody. So I just worry that we are, look, and as I've said in private, as as a criminal defense attorney, this is not such a bad thing for me because who knows whether there'll be lots more people out there that will need lawyers. But I just wonder if we are creating a scenario where everybody's going to be charged now with criminal negligence and then there's going to be a lot more people subject to jail time. I
think it's a reasonable question. And I know the subcommittee, I'll just be clear. I asked the subcommittee to consider putting these together, and I wanted to find a way to address these issues all at once. It's late in session. They're House bills. We didn't receive all of them back from the Senate, but I wanted to put them together as sort of a way to move things along. I'm going to hold this bill right now because I think that the questions that are raised are real questions, not necessarily about the grammar bill or the grammar or Schmidt part of the bill, but about the Delegate Wims part of the bill, where there is a question here that we need to start looking at as we come back every year over and over again and come with a different little thing that we're seeking to criminalize within the traffic article and the transportation article. We start, to Delegate Ambry's point and to Delegate Cardin's point a little bit too, the difference between vehicular manslaughter and criminal negligence, it becomes very difficult to tell after a while. And so I think we need to look at that for another second. I'm not saying that the other two are just, everybody else needs to, it's okay. But we still have a little bit of time to get it fixed. But I'm going to hold this just for this afternoon and we'll go from there. Now, are we ready with the Paris Hilton extravaganza again? Okay, Delegate Crutchfield is overwhelmingly excited and has just really can't stop her from talking about this bill. Senate Bill 400. Okay.
All right. So.
So there were amendments that were done. Do we have to do the amendments and then do amendments to the amendments? So we need first to do the committee amendments, the first set of committee amendments, and then Delegate Crutchfield will describe the next set of amendments and what the bill will look like as a whole. All right, so first, could I have a motion on the amendments that are 613720? Is that the first set?
613720, that's 10% of most recent, like around 11 something that takes the changes.
Okay, I'm sorry, that's not correct. So then I have the first set. The first set, which were printed here on March 28th at 4:01 p.m., are 863223.
It's still 613720/1.
Okay.
But if you look at, the only change from what the committee first had is on page 6 in the highlight, I showed the change to the 10-year statute of limitations.
Okay, so in 613720, you took the committee's amendments already, put them in and changed and made the change.
6137.
So we really only have to look at 613720 and the rest of the stuff is just stuff I made up. All right, that's good. So only looking at 613, there is only one amendment we're doing, 613720. I heard a motion on that amendment. Is there a second on that amendment?
Second.
Second, thank you. And now we're on that amendment. Delegate Crutchfield.
Okay. So there is another request for an amendment, and that is to change the language regarding attorney's fees at the bottom, let me see, of the reprint, which is going to be on page 5. Okay, yeah. Okay, so that is to now take out line 29 through 30, line 29 and 30, which deals with code that talks about
the court determining that an action is frivolous, because that language is not usually put into legislation. So that is an amendment on top of an amendment. And there is also a request to go back up into, sure. And did we talk about the victim reaches age of majority?
Yeah, they adopted that.
Okay,
That was in yellow.
okay,
And they was just taking that out.
okay, right, okay. And then if we go to page 6, just trying to make sure I got all the amendments. Okay, if you go to page 6, there is a section that deals with the right, that talks about the contracts. In other words, a parent can't waive the rights of a child in a contract. And so we need to remove the language that deals with that. That's going to be C1 and 2, page 6. And we're doing that because right now, if that language is included, then later on, a child possibly could not bring a claim, because what we're talking about is the parents being unable to waive the child's right to bring a claim, which means that the parents are now unable to settle the case while the child is still a child if they wanted to do that. And it precludes the child from bringing another claim later in life. So that's why we want to remove that language. So that's those 2 paragraphs.
All right.
Okay, so those are all the amendments.
Does everyone understand all of the amendments? Delegate Kaufman has a question. We've moved these amendments and seconded them, so we're on discussion of the amendments. Delegate Kaufman.
So, again, and I appreciate the fact that this was sent out, but I have so many bills swimming in my head. Delegate Crutchfield, so the statute would still be 10 years. I remember
Yes, everything, yes.
this
that is
morning, there was a lot of conversation about, well, if the child's 18, if it's this, so if you could elaborate.
Yeah, that language is still there. The difference is that we have now cleaned it up a little bit to say an action brought under this section shall be filed within 10 years after the date that the victim reaches age of majority.
Okay, so till they're 28, I guess.
Yes. Yes.
Okay, thank you.
Sure.
Other questions? On the amendments, all in favor of the amendment, please raise your hands. Anybody opposed to the amendments? All right, the amendment's adopted. We're on Senate Bill 400. Is there a motion? Motion for a favorable and a second. All right. So we're on the bill as amended. Is there any further discussion on the bill as amended? I want to genuinely thank Delegate Crutchfield and council for their work on this and for untangling a great deal of this. And I am, yes, many bottles of wine. All right. Are there any issues, any questions that anyone would like to raise? Seeing none. The Vice Chair.
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Carden? Yes. Tomlinson?
Oh.
No, because it's a Senate bill. But you'll have your time in a moment because
Coming up.
someone's district's mate's bill is coming up in a moment. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Dinette? Yes. Congolo? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Frank, is Conaway? It's accurate. Kaufman? Yes. Williams? Yes. Senate Bill 400 is adopted. Now, there are amendments then for House Bill 497 that would conform it to what we just passed. Move the amendments. All right, we'll take those amendments. Is there a second to the amendments? A second. Anyone with questions about the amendments? Again, seeing none. All in favor of the amendments to conform, raise your hands. Anybody opposed? Seeing none, the amendments are adopted to conform. Any objection for the vote on House Bill 497 being the same as the vote to House Bill 4, or Senate Bill 400? Wait a minute, Delegate Schmidt, that will be a thing.
I don't necessarily have a question per se. I've been working with the 1111 media team for a little bit, and I know some people are going to want to add on to this. I wanted to see if
I just realized that I probably need to do this the regular way.
Yeah, I was going to ask, obviously about adding on myself, but I was questioning if I could be added in second position with Delegate Stewart.
Generally, don't. I mean, you're just adding on in the committee now at this point.
All right, I just figured I'd ask. So it was pre-filed, so I was unable to get on there.
Good job.
Yeah.
Fought like a tiger.
If I didn't ask, you wouldn't be able to say no.
All right. So we're going to,
Thank you.
I'm just going to call a regular vote because people would like to potentially add on. All right, the Vice Chair.
Can you just say, is this 497?
497, House Bill 497, which is in the same position as Senate Bill 400.
Thank you, yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes, and add.
Yes, I would imagine. And an ad? Carden?
Why not?
Yes, and an ad?
No.
All right.
Why not?
Tomlinson? Yes, and an ad? Yes, and an ad. Embry? Yes. Pasteur? Yes, and an ad. Tolles? Yes, and an ad. Schmitz? Yes, and an ad. Simmons? Yes, and an ad. Boucher? Yes. Phillips? Yes, and an ad. Stinnett? Yes, and an ad. Congolo? Yes. Taylor? Yes, and a can. Yes, and an ad. Simpson?
Yes, and an ad.
Yes, and an ad. Grammer? Yes, yes, and an ad. Yes, and an ad.
Conway all choked up.
Oh, boy, 5 days, huh? Sample Hughes? Yes, and an ad. Moon? Yes. Conaway?
Yes, and I will hear that at the party next
Yeah,
year.
yes, and an ad. Kaufman?
Yes, and an ad.
Yes, and an ad. Williams?
Yes.
Yes, just a yes. All right, the motion is adopted to House Bill 497. So those two are moving right along. Now, the last one that we have for right now at 3:25. So we're going to go for a little bit of time talking about this, but you will have just received changes to Senate Bill 828, which is the sensitive locations bill. I believe there may be a further change that may be coming to this bill, but for the moment, what I'm going to do is, Holly, do you want to go through what the bill does right now? So we're going to ask council to go through what the amendments to the bill would do. As the committee will remember, sensitive locations was added on, I think, to the U visa bill when we sent them out of the House. They're in different vehicles now, so we're looking at the sensitive locations bill alone and the sensitive locations portion of the bill alone. So with that, Holly, if you would just go through, we're just going to talk about it. We'll talk about it here for a little bit, and then we'll have a voting session, and I will kind of give people, their warning that you got to get amendments in. Holly, go ahead.
Okay, so let's start. I'm just going to go by pages. Starting on page 2, you'll see this is a part that was in House Bill 579, the U visa bill. It clarifies that federal law enforcement officers must notify certain individuals of federal immigration actions at certain sensitive locations. And you'll see this in the middle of page 2, subsection C. Again, this was in House Bill 579 as we passed it out. And then if you go to the bottom of page 2, we're now in section 2-104.2. This came over in the Senate version of the bill. This is a warrant requirement, which requires that a unit of the executive branch of state or local government that operates at a sensitive location to deny access to any portion of the sensitive location that is not accessible to the general public to any individual seeking access for the purpose of enforcing federal immigration law unless a warrant is issued by a federal court. And then you'll see that this section, this subsection also we added in. It does not apply to state or local correction facilities. That's as the bill came across from the Senate. We added in or the detention facilities in a district or circuit court. If you continue on to page 4 of the bill, we're now in section 6-111 of the state government article. This is where sensitive locations are defined. We kept the Senate version of sensitive locations, except with one change. Sensitive location is defined under the bill as a public school, a public library, a healthcare facility operated by a unit of state government, a facility operated by the comptroller, or any other location that provides state-funded services related to physical or mental health, education, or shelter care, and as determined by the Attorney General, which requires special consideration for immigration enforcement activities. We, in this section, strike a courthouse. The amendments following the sensitive location come from, we strike the provisions that came across in the bill relating to the Attorney General developing guidance, and we take the version that was in House Bill 579, which was more expansive, and you'll see this starting on page 5, subsection B. This is where the Attorney General shall develop and publish guidance related to immigration enforcement actions, and you'll see a list of 8 different provisions. And that, again, was in House Bill 579 as we passed it out. We keep in the bill subsection D that on or before October 1st of 2025, each unit of the executive branch of state or local government that operates at a sensitive location shall implement the policies that the Attorney General develops under the subsection A, or B, apologize. And then we keep also in the bill the guidance and policies required under this section are not subject to the Administrative Procedure Act, which is governs procedures for state regulations. And that's the bill as it stands right now with all the changes.
Thank you very much. We thank you very much. So there are parts of what we passed, including the language that Delegate Moon added to existing law that just makes it clear that a federal immigration enforcement action is an enforcement action for the purposes of the criminal procedure article. So that was language that we included, and I think, again, helps to clarify that they would still have to call, if they were going to go in an enforcement action, the chief of police, police commissioner, or the sheriff, depending on who the lead law enforcement agent is. But we take the language from the Senate. When we passed our language over, our language dealt with both public and private places. We go along with the Senate and say that we're going to just focus on public places. And to take their language that requires that the person who is going to be enforcing federal immigration law has to provide a valid warrant that is issued by a court. There's a question in my mind as to whether a state court would have any ability to actually issue one of these warrants. And so it says court. We did federal court? Oh, I'm sorry, we did federal court. I apologize. So we're making it clear it needs to be federal court as opposed to a state court. So we took a fair amount of what was in the Senate bill and made some of the changes that were listed there. And with that, you have it before you. We will not vote on it just yet because I think there's going to be other questions and other changes. But I'll take questions now, and we'll go to Delegate Williams.
Mr. Chair, I just also wanted to add, there's a provision there that says the Attorney General may develop and publish guidance for non-public facilities about immigration enforcement to address some of the non-public facilities like churches and things like that.
Yeah, it allows, and for what it's worth, it does allow him to create standards for non-public facilities, but it only requires them to be, those policies to be implemented in public facilities. And we kept, I think, some of the House language that was a little more specific about what we wanted the Attorney General to do, and we moved that over and added that in with the Senate language. All right, Delegate Phillips.
What was the reason for taking out the private facilities that we had identified, like churches? Was there anything constitutional that were there any concerns with?
I mean, as was mentioned, I think the Attorney General is going to provide some guidance, and I think the question becomes, how far do you go here? I mean, where do we have the ability to legislate and where don't we? And I thought that we were better in this area of the law sticking to the public facilities, and that was at least consistent with the way that the Senate bill came across. So part of it is just in the back and forth between us and the Senate, finding something that was, I mean, I don't want to trivialize the public place or private places part of this, but at the same time, it was trying to say, okay, well, the Senate thought this was important just to keep it at public places, fine. We can go along with that and then go from there. Again, that's why also we left in the language for the Attorney General to provide guidance to private places. We just don't get into actually requiring something about it.
So there would be no cause of action. In this particular case, we might have a cause of action. I know it would be state action versus federal, but there would be no protections at this point that you might have in a church to reduce this opportunity for some type of violence to occur.
I mean, I'm not sure. So under this bill, no. That's the question. And kind of the reason also why we're out here talking about it now and whether we want to go down that path or not. Again, the idea, as far as I saw it, was to try and kind of take things that seemed like more of a House priority and put the two of them together because we don't have a whole lot of time left while still meeting the goals of the legislation as a whole. So I'll just say, I mean, if that's a path you'd like to go down, that's fine. I do think that the Attorney General needs to provide guidance, and that's kind of why that's there, is they should be able to provide guidance, and if it appears that we need to put something in the future that's specific to private places, then we can come back and do that.
Well, as you heard this morning, I'm a pragmatist. This has already passed the Senate.
So we've taken a big chunk of what the Senate did. It's still here. We've added parts of the House bill to it, and then we'll be sending it back to the Senate.
And do we have some sense that they're ready to vote on what
I believe, but at this point, I will be going over and looking people in the eyes and finding out. I don't want to put us in the position where we're just sending something over willy-nilly either, which is also the reason. If people have questions or concerns about the bill now, I'd rather have them now, and then I can talk to the Senate and see if we can address those concerns today as opposed to after this starts bouncing back and forth.
All right, thank you, Mr. Chair.
Thank you. Are there other questions? Because I just realized we had another bill that I forgot.
Yes, Mr. Chair.
Delegate Kaufman?
I'm wondering if, and if the answer is no, that's okay, but I'm wondering if Delegate Martinez as chair of the Latino caucus or Delegate Wilkins, who was the original sponsor of the sensitive spaces, have had an opportunity. Are they okay with the changes, or have they never had an opportunity to look?
We're here now, and at this point in session, I wanted to talk to the committee first.
No, that makes sense. No pressure. I was just curious.
But so that's why the talking happens now, and then we'll go from there.
Thank you.
All right, so it's in front of you. It's something that you can review. I have a feeling people in the front row over there might want to see it too. And so that's perfectly fine, and we'll hear back from people, and we'll come back to this tomorrow morning. We will vote tomorrow in the morning at 9 o'clock on this legislation. In the meantime, there was one extra bill Oh, is there one extra bill? Senate Bill 585. Senator Waldstreicher. It's an exception to the armed trespass prohibition. Going back in time to Senate Bill 1, back in the first year of this term when dinosaurs roamed the earth. We went back and forth in trying to fix a question that had to do with retired police officers and their ability to wear and carry a firearm in places, in property that was not their own. The FOP and other police organizations have pointed out that no, it never has gotten fixed. All that this bill does is it moves the allowance for a retired police officer to possess a firearm from the part of the code where they are permitted to possess it, to wear and carry it under the wear carry statute, and moves into the trespass statute where it was prior to SB 1. We need to fix that change, so thus Senate Bill 585, and there's a motion and a second. Are there further comments or questions about this? Delegate Conaway.
Mr. Chairman, that was a beautiful speech and everything, but in regular people's language, is that saying that the police officer now can go and investigate on another person's property?
They could before, and so they could before before SB 1. They were included in, and this is retired police officers. We're not talking about police officers doing investigations on people's property. We're talking about retired police officers who happen to be possessing a firearm. And they were included in that. They were included in that prior to SB 1 passing in 2023.
So this is the bill that came in where they said that they could identify a car or someone that doesn't belong in their neighborhood.
I think that was that this one, or was that the other one? No, that was his.
The hoopty one?
The hoopty bill was the other bill.
Okay.
Again, just to be clear, the hoopty bill was the other bill, and that was, that was.
So this bill is going to allow the retired police officers
to have the same ability to possess a firearm on private property that they had prior to Senate Bill 1 passing in 2023. But the vice chair.
But because it is
home, okay. But because it's someone's home, they have the right to refuse.
Right.
The entry of that retired police officer.
this should happen and go wrong, would the officer be taking on his own personal liability?
I think so, yeah, he's retired.
All right.
They're not under the same,
Okay.
yeah.
Thanks.
I spoke to my expert.
They do so at their own risk, yes. Delegate Taylor.
Just clarification, was it an oversight that we didn't do this, or did we intentionally
Let's
take
go
them
with
out?
oversight, but I will tell you that we spent time even during SB 1 trying to figure this out, including, I would say Delegate Arakan was part of a group where we were trying to fix this problem then. We have finally, I think, got it in the right place. This is where it should be. And this should address the issue and address the concern that they have. So thus, we are here today. Are there further questions? There was a motion for a favorable and a second. Here we are. The vice chair.
Yes.
Yes, Valentine.
Yes.
Yes, Crutchfield.
Yes.
Yes, Cardin. Yes, Tomlinson. Yes, Embry. Yes, Pasteur. Yes, Tolles. Oh. Schmidt. Yes, Simmons. Yes, Boucher. Yes, Phillips. Yes, Stinnett. Yes, Congolo. Yes, Taylor. Yes, Simpson. Yes, Grammer. Yes, Sample Hughes. Yes, Moon. Yes, Conaway. Yes, Kaufman. Yes, Williams. All right, that favorable motion is adopted. Again, we will take up sensitive places tomorrow morning at 9 a.m. giving the committee the opportunity to look at the amendments before you. If you have amendments that you would like to propose on the legislation, please, this is your fair warning, just as we did on the other bill from this morning. This is fair warning. You have the time to go to the amendment office and request those amendments now and make sure that they are here before the beginning of the voting session tomorrow morning. With that, this has been the House Judiciary Committee. Thank you very much.